My name is Kartik Chawla. I'm a PhD student here at the Department of Management and Information Management at Tilburg University. And I have a background in law and law and economics. And it's an honor to be here to be here for the feedback, for all of the amazing discussions. The topic of my thesis is transactions on privacy and the tools that assist users in such transactions. And we take an interdisciplinary perspective to this issue because we believe that it's important to consider this from the perspective of not just law or technology, but both, and take into account the market forces, the business circumstances as well. Individual users such as you and I, we contract on privacy on a regular basis. We interact with standardized digital contracts such as terms and conditions every time we visit a website, every time we download an application and agree to its terms. But these are, and these contracts often include terms about how they handle personal data, what impact they have on our privacy. And these transactions should be governed by the terms and conditions. So the user in such a transaction explicitly or implicitly provides personal data to the service provider or provides payment in exchange for receiving a particular service from the service provider. And this should ideally be governed by the terms and conditions of the transaction. However, these terms and conditions and this whole the process that results in the creation of these terms and conditions and the process that is carried out after we agree to these terms and conditions is not necessarily efficient. It does not necessarily enable private ordering. And we will come to the problems that users face in the next slide. And the methodology that we use to address this problem is the design science problem, the design science methodology, the first step of which is problem identification. So in the first chapter of my thesis, I look before coming to the problems actually. So to understand the interaction of users and service providers in the context of the terms and conditions, we use the lens of the contractual life cycle to organize this process. We draw this flowchart on the basis of Governatore et al.'s paper, depicting the various stages that users go through in interacting with the terms and conditions with the contract. And then we further categorize this into 3 phases. The first one is the negotiation and formation phase, where the users are interacting with the service provider and setting the terms of the interaction. This is also where the modification stage would come in, and this is where the storage and notarizing, if necessary, of a contract should happen. The second phase is where the users interact with each other and the real world to ensure that the terms of the contract are actually being put into effect, they're actually being performed. And in this phase, both the parties also monitor each other, should ideally monitor each other for compliance with the terms. We also add a technical enforcement stage here, which is an exception, and we will come back to that in a later stage, in a later slide. And finally, we have the dispute resolution and termination phase, where users and the service providers may interact with each other in order to resolve a dispute, or they may interact with third parties such as arbitrators, regulatory authorities, or the courts, or where they may simply terminate the interaction. Now, in the first chapter of the thesis, we conducted a descriptive literature review of legal literature on the problems users face in these interactions. And this is an early stage results, but there are clearly quite a lot of problems that users face, and these problems are not necessarily limited to transaction costs. They're not necessarily limited to a particular subset, but for instance, users also face behavioral problems in interacting with these policies. But one of the most common and underlying problems across the first 2 stages at the very least is opportunistic behavior, where the user has to be careful about the service provider acting opportunistically. And in the literature, a lot of focus is usually on the notice and consent, the negotiation and formation parts of the problem. But as we will argue later, the other parts of the problems are also crucially important. Now, a lot of these problems can be addressed with privacy enhancing tools, which are the focus of our analysis, but some of them still can't. So for instance, in dispute resolution, and if you actually want to take a privacy claim to court, one of the bigger problems tends to be establishing privacy harms, and that's not an issue that PETs, I would argue, can currently assist users with. So to set the stage for our analysis, we limit ourselves to a total of 5 stakeholders. The first two we discussed were the user and the service provider. The third is the legislature, which may create legislation that provide default rules for the terms and conditions, or they provide prescriptions for the transaction and the entity's behavior in that itself. They may also create a regulatory authority that enforces these default rules or provides guidelines for their implementations. And crucially, we also look at developers of privacy enhancing tools. And these developers may come from the legislature or, they may come from academia, from the industry, from regulatory authorities. And they create privacy enhancing tools to help users with this transaction. The tools may also be created by the service provider itself, and they may or may not interact with the terms and conditions themselves. This scenario is a little bit context dependent, because the same entity that is a service provider in one interaction may very well become a third party in a second interaction. So for instance, if you're interacting with if you're interacting with Apple directly on an iOS device, Apple is the service provider. However, if you're interacting with Instagram through Apple, then Apple becomes a third part, a service provider intermediating your interaction with a third-party service provider. And we do not focus too much on these third parties currently. And for today's discussion, we focus on the privacy enhancing tools and their developers. Now, as we saw, the users face a lot of problems across the life cycle of the contract, across each of the 3 phases. And as we will elaborate in a little bit, these problems are interlinked. So our working hypothesis is that an end-to-end contractual or transactional privacy enhancing tool should be able to assist users in each of the phases of the contractual life cycle with the problems that are relevant to that part of the life cycle. And it should help users it's a support tool. And why is such a tool needed? We aim with this tool to give users a sort of bottom-up empowerment. And we base this on the idea that a contract changes incentives. It forces a party to act differently because it is enforceable and it is enforced. In the second chapter of my thesis, we can conduct an overview of existing tools, existing legal interventions, and existing privacy enhancing tools in order to find out what the coverage and the gaps in this life cycle are. But that is the generic level of the analysis, and we instantiate this analysis into a narrower scope, into the scope of cookies and cookie policies and cookie consent managers to make it a little bit more practical. And as Schwab et al. Note, privacy policies are often written for the purposes of compliance, but the actual negotiation of defaults, what Mirel Hildebrand calls the negotiation of defaults in the on-life era, where users actually select which options apply to them, that happens in the context of cookies through cookie consent managers. Now, to specify this context, we have Jane Doe, a user who wants to access a website called Proton News. She wants to access some of the content that is on that website, and in accessing this content, she's also becomes an audience to certain ads that Proton News is displaying as part of its own revenue model. Jane Doe potentially provides some payment and maybe even provides some personal data as part of this transaction. The terms and conditions may not explicitly state that the personal data is provided in exchange for that service, but they may just state that this data will be collected if you use our services, and these are the options that are available to you. So the cookie policy is what sets this apart, but cookie consent managers are what give users the options to interact with this. In our context, Jane Doe is a resident of Amsterdam, and therefore the EU and the Dutch Parliament together create regulations such as the GDPR and its local implementation, the AVG, and the e-privacy directive and the Dutch Civil Code, which affects this transaction. We also have the Authority Persona Gegevens, which enforces these default rules and also provides guidelines for this interaction. But our focus today is on this side of the transaction, of the context, where you have developers providing privacy enhancing tools that assist Jane Doe in this transaction, and where you have Proton News providing its own cookie consent management platform. So just the model that I mentioned earlier, the broader model of problems users face in interacting with the transaction on privacy across its life cycle. we apply the same as much of that model here as it fits into the context, and we further conduct some analysis to identify particular problems unique to this context. And to put it into the same scenario, when Jane Doe first arrives on the website, on the Proton News website, she faces the cookie consent manager, the banner that comes up in front of her, and she at that point has to take the steps, the negotiation and formation steps. She has to go through the options available to her. She has to make effective choices, identify the parties, the third parties, and this is where she faces ex-ante negotiation costs relating to the complexity of the documentation, the complexity of the information, even in the cookie banner, the potential for dark patterns, and also crucially, whatever consent she gives, it's usually hard for her to be actually able to store that consent locally. And this, even if she crosses all of these problems, even if she deals with all of these problems and makes effective choices about her consent, she then enters the second stage where both the parties are performing their parts of the contract, and where they are monitoring each other for compliance. And this is where she faces the second problem, because even if she makes the effective choices, she has very little by way of an option to ensure that those choices are actually being followed. And this is a problem not just for Jane Doe, but for regulatory authorities as well. Now, if you see on the right side, there is some recent research that has been conducted on problems users face with cookies. And at the bottom, a lot of these problems focus on the negotiation and formation stage. But in Mate et al., their study, they've analyzed 508 websites, and they found that 5.3% of those websites did not respect the choice of the users, even after the users actually put in consent, denied consent. And then finally, let's say that Jane Doe makes the effective choices, that she finds out that her choices are not being followed. The third problem that she faces is, how does she actually complain about this? How does she actually file a case if she can? How does she enforce that part of her rights, contractually agreed upon terms? And so, for addressing this, we come to the second part of the design science methodology, which is an analysis of existing solutions. So we conduct a state-of-the-art study of the technical interventions that are available. We conduct this in a broader form in chapter 2, but for this, for right now, we have a purpose of selection of cookie consent management and tools that assist users with cookie consent management. And we do this in order to avoid the greenfield fallacy. We want to see what tools are available, what existing tools can do, and how we can build on top of that, or how we can contribute to that. Now, the first tool that comes up in our analysis is the cookie consent manager provided by the service provider itself. And I'm not going to go in detail here on that. But perhaps no discussion of privacy enhancing tools, and especially cookie related privacy enhancing tools, is complete without discussing the platform for privacy preferences, which was one of the earliest privacy assistants to exist, and which was quite an interesting idea, and it was quite well implemented also, but it failed to find adoption in the market. It failed to, and even when it was adopted, there were significant problems with service providers acting opportunistically, abusing the notation and miscommunicating their privacy practices. Another protocol that tried to do something similar was the do not track protocol. And that also faced significant adoption issues. Especially if you read privacy policies nowadays, you would find that at least somewhere some of them tend to have a clause that says we do not respect the DNT signal if you're sending that out. But one interesting tool in this stage is, and one more recent tool, is a tool called Concentramatic. And this is based on research conducted by MIT. And what they did was they analyzed the cookie consent managers used by multiple websites. I think they analyzed over 600 websites for this. And they created a rule set based on that. And the purposes that you see on the left-hand side, you can automatically select, you can pre-select which of these you would like to allow across websites. And then every time you visit a new website, it automatically communicates your preferences through the cookie consent manager given on the website itself. So this does two things different from the previous two tools. The first is that it relies on the GDPR and on the structures created by the GDPR. And the second is that it incorporates a principle they call adversarial interoperability in order to ensure that their tool does not face the same adoption issues. But again, this tool can help Jane Doe in communicating that she does not want to give consent to any of these purposes, but it does not actually help her monitor whether this consent is being respected or not, which is where we come to the second tool, cookie classes, which is based on the research conducted by Mate et al. And it is a scaled down version of a different tool that they developed for testing cookie consents, but this is also both of these Concentramatic and cookie classes are Google Chrome web browser plugins. And this essentially decodes the consent string stored by the consent management platform to help you see what consent has actually been stored, and so that you can ideally compare it to the consent you wanted to give. And we also, in this context, in the context of monitoring for compliance, it's also important to mention privacy seals such as Europrise Website Privacy Certification, which are not PETs, but they can act as signals from the service provider to the user of compliance within their own limitations. But the third tool that we discuss is the EFF's Privacy Badger. Now, one of the things that this does differently from the other two tools is that this is not necessarily what we call contractual tools. It does not necessarily deal with the terms and conditions given in the transaction itself, especially in its third set of functionalities. But what this tool does do is that it enables a technical enforcement of the user's privacy preferences. It is based on the web browser, and because it acts as an intermediary between the user and the service providers as actual functionality, it can help the user implement their privacy preferences at the browser level. And in a way, insofar as it does not interact with the contract itself, it's a signal of the user's privacy preferences. And to put it differently, we call these signaling tools that do not interact with the terms directly, but signal user preferences. So for instance, if you use an ad blocker and you end up on a website where they ask you that, please, we rely on this for, we rely on ads for our revenue, so can you please disable your ad blocker? That's a mini negotiation that takes place right there. And finally, the dispute resolution, to be honest, dispute resolution is where the least amount of tools were found in this analysis, but we did find this the cookie complaints tool released by the UK's Information Commissioner's Office, which allows users to submit complaints about, submit concerns about websites which are using cookies or similar technologies. Now, one important thing to note here is that the Concentramatic based its rule set on an analysis of CMPs and on the GDPR. And this is similar, except this relies on the IAB's transparency and consent framework. And they both have similar, they both rely on the GDPR, they both have similar roots, but as you can see, some of the purposes that they talk about are slightly different. And that brings us to the issues faced by third-party privacy enhancing tools. The first set of issues they face are interoperability and adoption. This is what we saw with P3P, with DNT, and with Concentramatic. Insofar as that the tool needs to be adopted by the users themselves, but a lot of PETs don't end up being adopted. In conversations, in informal conversations with the experts in the field, they note that these tools always come up for some time. They're interesting ideas, but they don't last very long. But on the other hand, these tools also need to be adopted by or be interoperable with the systems of the service providers. Otherwise, the communication of user preferences doesn't take place, just like with Privacy Badger. But the other part of this is also that each tool, in selecting its scope, in selecting the term purposes it deals with, in selecting the definitions it allows, defines privacy in its own way. Or rather, the privacy it enhances as a privacy enhancing tool. And the next issue is that while there are tools like Privacy Badger that help users enforce their privacy preferences, their scope is limited to the data that they have architectural access to, that they have, that they can actually control. And in doing so, this leads us to the third problem, which is that in order to protect your data, they need access to all the data that you need to protect. So they actually have a higher risk of opportunism at that level, or rather a higher possibility of harm from that level. But and to be fair to these tools, rather than monitoring 100 service providers for opportunism, these tools allow you to monitor only one service provider. I'm going to go through the rest quickly because I'm running short on time. But so based on this analysis, we created this sort of framework for the next steps for us. And these are the steps that we personally went through in the selection of the design requirements for an end-to-end consent management PET. The first step was the selection of a clause. Rather than dealing with the whole privacy policy, we decided to deal with the smaller subset of cookies, of terms relating to cookies. There are other PETs that don't do so. For instance, Policies is an excellent tool which uses machine learning, but it works on the entire privacy policy. The second selection that we make and we see other PETs making is the selection of a legal or in some cases non-legal framework to assist in their function. So for cookie glasses, this is the consent. This is the IAB and transparency. IAB is a transparency and consent framework. For Concentramatic, this is GDPR. The third is the deployment context. Web browsers, Android phones, IoT devices. In our survey of PETs, we find that there are a variety of contexts that they are deployed in. And they make and each of these scope selections have an impact on the functionalities that they can enable. And also on the knowledge representation and reasoning model that should and is necessarily, it's a prerequisite to be able to enable any of these functionalities. And finally, we would argue that you need such a tool needs 3 sets of functionalities that deal with each of these 3 sets of interrelated problems. Now, I have a set of requirements for the tool, which I'm going to go over for now, but so we have not addressed the costs of deploying PETs in our limitations. We have not addressed who should actually be bearing the cost of implementing these PETs. We have not as of yet dealt with hybrid interventions, so PETs plus legal support for them. And we have not yet gone into the realm of the actual knowledge representation required to coordinate such a PET across the 3 levels. We would like in the further steps to design a proof of concept PET, but before that, we would also like to validate the problems we have identified via qualitative interviews and the solutions we have proposed. We would also like to, we do have a tool, we would like to conduct expert validation for the same. And ideally, we would also like to conduct an FSQCA-based user experiment to test the tool for perceived usefulness and perceived ease of use. And we select FSQCA for this because it allows for a configurational analysis and to see which combination of functionalities do users appreciate. We would like to do this to have the users have a control with a regular privacy policy or one of the other tools from our analysis. We would also like to consider generalizing the framework that we've come up with to consider it as a framework for further analysis of privacy enhancing tools and how they fit into the contractual lifecycle. And thank you for your time. Once again, it's my absolute honor to be here. These are some early results from my research. And if you have any questions, please do let me know. And please feel free to reach out on my email at any point.
Thank you so much, Mr. Kartik Chawla. We have one question from the audience, and it's from Andre. And the question is, I was thinking by reading your paper, always about parties who signed the contract needed to renegotiate its clauses to adapt the documents according to their needs. But then you suggested that governments could implement TPTs. Could you explain a little further on the advantages of government imposing TPTs?
I'm sorry, I couldn't catch that clearly.
Sorry?
Can you repeat the question?
Yes, I can repeat the question. The question is from Andre, and he says that I was thinking by reading your paper always about parties who signed the contract needing to renegotiate its clauses to adapt the documents according to their needs. But then you suggested that governments could implement TPTs. Could you explain a little further the advantages of governments imposing TPTs?
No, I would not recommend. So privacy enhancing tools can be implemented by various parties. And there's a cost benefit analysis that goes into that. There's an excellent paper by Hanneke Lutz about the cost benefit analysis of consumer protection interventions and who should bear the cost, the government or another entity. But for example, recently the EU government proposed a plan for a digital EU wallet, which acts as an identity authentication system and lets users mediate their data interactions with other third parties. So essentially, when you use a third-party tool like that, it changes this context because then Jane Doe is interacting with the wallet, and then that wallet is interacting with the third party, and whether that, so if a government is implementing such a tool, the benefit there would be that the government can actually enforce the compliance with those tools. But there is no reason to say that other parties could also not implement similar tools. They would compete in the market. There would be and there would be benefits and drawbacks for adoption on various sides. But yes, I don't see why it should only be the government that implements such a tool. Other parties could also do so.